Okay, let's get started. Welcome everyone to our webinar today. I hope your Fridays have got off to a great start and we hope that we can keep that momentum going. We will be covering the topic of what the Industrial Relations Fair Work Bill means for your business. My name is Wayne Baker and I am the CEO of Symmetry HR and have been at Symmetry for 10 years. Symmetry HR provides solutions in casual and permanent recruitment from entry-level roles all the way through to senior management and executive leadership roles. We also provide HR advice on industrial relations law and best practice workforce management principles to businesses nationally. Our expertise sits within the manufacturing and logistics sectors, public and private hospitals, aged care facilities and head office based type roles, including administration, contact centre, finance and sales. We invest our resources heavily in the understanding of your business so that we can then support you with our service offering in the best way possible. It is great to have everybody in attendance today. Looking forward to what this webinar can bring. So what can we expect over the next hour? So here's some bullet points that we will go through in order to let you know some of the things we will cover. How to classify and manage temps, how to manage the casual conversion of casuals to the permanent work process under the new law, how to provide potential back pay claims for your current casuals, how to manage the 6-month transition period into the new law, how to manage changing award systems and overtime interpretations, and how to strike better pay deals if your business has been impacted by COVID. Just a couple of housekeeping matters just before I introduce our special guest. All questions that have come through the chat box, including technical and of course topic-based questions. There will be a Q&A with myself and Nick after his presentation, where I will be drawing questions from the chat box that you, the audience, have provided. So without any further ado, let me introduce Nick Tindley. Nick is a partner with FCB Workplace Law and the Executive Manager of HR Consulting and Advisory Services at FCB HR. Based in the Melbourne office, Nick has over 13 years experience in providing industrial relations and employment law advice. In his role as Executive Manager, Nick oversees both the consulting and advisory teams at FCB HR and is responsible for managing a number of key client relationships. Nick also manages the advisory services for the Australian Retailers Association, the Recruitment and Consulting Services Australia, which is the RCSA, and Victorian Association for Newsagents and Fitness Australia. Nick also participates in the Workplace Policy Committee of the Australian Chamber of Commerce and Industry and facilitates the RCSA's Workplace Relations Working Group. A few other things about Nick. He loves to get away to Peterborough, which for those that don't know is about 3 hours from Melbourne on the beautiful Great Ocean Road. He's an avid Collingwood supporter in the AFL, so don't hold that against him. And I welcome to the webinar today, Nick Tindley. Welcome, Nick.
Thanks, Wayne. Very exciting introduction, mate. Definitely more impressive than I feel, but thank you for that.
Good on you.
And thanks for the opportunity again to present to the group. It's a pretty exciting but at the same time challenging time in my world, the world of employment law. We've got this new legislation that's going through the Senate process at the moment. So it's been through the House of Representatives. It's been put off to a Senate committee that's conducting hearings. Actually appeared at the hearings last Monday. There's another round of hearings next week in Canberra, and then the Senate committee will give its report. But the real kind of heart of all of this is the negotiations between the government and the crossbench about its passage through the Senate. So, you know, the Labor Party's opposed to it, the Greens are opposed to it. So it really sits with the crossbench. So we're going to be talking today about the provisions of the bill, and with a clear focus on casual employment, because it is probably the most significant area where things will change if we assume the bill goes through in its current form. There are likely to be some amendments to the bill, but I think most of what we'll talk about today will be in either in its form that we speak about today or in a slightly varied form. In terms of timing, my expectation is that the bill will pass into law possibly late March, but probably more likely early April. So that gives you an idea of the timeframes that you're playing towards. This I'll be clear, this is not going to be the most exciting webinar in the context of what I'll be presenting, because I really need to talk quite kind of clearly through the legislative changes. And as I said at the start, there'll be a focus on the casual changes. We'll look at some of the other changes, a bit of a summary of what it all means and how you can either mitigate your risk or actually take advantage of some of the provisions. Unsurprisingly, because this is a coalition-led change, there are some elements that are quite friendly to employers. So I'll start off with casual, and there's three key areas. There's a definition of casual employment. There's some provisions around casual conversion. There's the critical double dipping element to it. And so in terms of definition, what the bill says is that a person's a casual if an offer of employment's made to them on the basis that there's no firm advance commitment to continuing an indefinite work according to an agreed pattern. The person accepts that offer on that basis and they become an employee as a result of that acceptance. So the most critical part of that is the firm advance commitment element, because that's where, for anyone who's attended the previous webinars that we've done, that's where the problem with the Skeen and Rosado cases really arose around this concept of firm advance commitment. So what the legislation's done is to provide factors that a court can consider when determining whether a firm advance commitment has been given. And I think helpfully from an employer's perspective, it is an exhaustive list. So that a court can't consider anything beyond these matters. So whether the employer can elect to offer work and whether the person can elect to accept or reject work, whether the person will only work as required, whether the employment's described as casual employment, and whether the person will be entitled to a casual loading or a specific rate of pay for casual employment. They're relatively simple, straightforward requirements. The only aspect of it that I think creates a level of uncertainty is this concept of whether the person will work only as required. But I think that the intent of the legislation is that doesn't preclude kind of ongoing casual work, but really deals with casual work. They're not being an absolute locked-in arrangement. Helpfully, to avoid doubt, a regular pattern of hours does not of itself indicate a firm advance commitment to continuing an indefinite work. So that's really helpful. That means that if the employment becomes something different after the employment starts, and that's similar with the next element. If you engage a casual employee, the factors that determine whether a firm advance commitment have been made fall in your favour, and subsequent to that, the employee starts working a much more kind of regular pattern of hours, then that's not that doesn't impact the outcome of whether they're a casual employee or not. If you the post-engagement conduct doesn't change the definition and can't impact on the way a court considers the definition. It is all about what is agreed to at the time that the employment is entered into. So that's a really critical change, and will alleviate a lot of the concern around employees who have been classified as casuals actually being treated as permanent, or actually being deemed to be permanent employees. And if an employee accepts an offer of employment as a casual employee, they remain a casual employee until either they convert or they accept an alternative offer of employment from the employer. So that what that is saying is, again, it's almost saying, to be honest, saying the same thing 3 times, is that you don't change until you don't change by your post-engagement conduct. You only change if you enter into a different agreement, which is either a conversion or an alternative offer at a later time. So that is, from an employer's perspective, a really helpful definition, and will mean that the vast majority of people who are engaged as casual employees are at law casual employees, provided you do certain things, and we'll talk about that later in the session, about the types of things you need to do to make sure you're not stepping outside this definition. With every lovely thing that occurs, there's a challenge, and the real challenge in this bill is the casual conversion. It's a challenge, not from I don't think from a practical perspective that we're going to have a wave of casuals converting to permanent employment. It's a challenge from the perspective of the administration attached to it. So most of you will be familiar with casual conversion processes in modern awards or enterprise agreements. This is a quite different process to the standard provision. So about 2 years ago, actually closer to 3 years ago now, casual conversion clauses were inserted into a number of modern awards that didn't have such a clause, and it was essentially a right to request conversion once someone met certain trigger points. What we have now is an obligation for an employer to make offer of permanent employment to casual employees if certain criteria have been met. And you can see from the slide that it's a twofold test. The first component is that the employee has to have been employed for a period of 12 months. So your first trigger point, when did they start? Have they got to 12 months? Yes. If the answer to that is yes, then an assessment needs to be done, and that takes you to the second part of the test, and that is the employee's worked a regular pattern of hours on an ongoing basis in the last 6 months of that 12 months, that without significant adjustment, they could continue to work as a full-time employee or a part-time employee. Now that's quite a critical consideration, and will be driven in part by whatever regulates full-time and part-time employment for that particular person. So if you have an employee who's working in a warehouse, for example, they're a casual employee, they've been working for 12 months, you look at the 6-month period, and if they've been working part-time hours, you then also look at the part-time provisions of the relevant industrial instrument that covers their employment. So if it's a storage services award, for example, you would need to look at that award. And when you did look at that award, you'd see that the part-time provisions are very, very set in stone and inflexible. And so if that casual employee has worked a moving number of hours during that 6-month period, on its face would mean that they're not entitled to be made an offer of permanent employment, because they couldn't continue to work the pattern of hours that they have been as a part-time employee, because it wouldn't comply with the part-time provisions of the award. So whilst there's been, I think, from employers some frustration about the inflexibility of part-time employment provisions in modern awards, that the existence of them makes casual conversion a kind of lower risk in terms of employees having that eligibility. So you can see with that assessment process that there's, so the 12-month question requires some sort of system to identify when someone's got to their anniversary, and the 6-month thing requires an element of human analysis of hours of work and industrial instrument provisions. If an offer is to be made, it must be made in writing. It must be for the equivalent full-time hours or part-time hours consistent with the pattern of hours that they'd worked, and most critically must be given within 21 days after the end of the 12-month period of work. And so you can see, as soon as you hit that 12-month point, you're on a timer to get this process worked through. And if you engage, multiple casual employees, the task is quite significant. You can refuse to make an offer to an eligible casual employee if there are reasonable grounds not to make the offer based on facts that are known or reasonably foreseeable at the relevant time, so that the time that you decide not to make an offer. Those reasonable grounds, and this is not an exhaustive list, but it's intended to provide guidance. The position will cease to exist in the period of 12 months. The hours of work which the employee is required to perform will be significantly reduced in that period. There'll be a significant change in either or both of the following: the days on which they work, the times at which the employee's hours are required to be performed, which can't be accommodated within the employee's availability. And the last one's just a kind of a nod to the state and federal governments, predominantly around their obligations around recruitment and selection processes and advertising roles. So those reasonable business grounds are really about, is this role still going to be there in the same way that it is now in 12 months' time? And if it's not, that's a reason to not make an offer. So that's your next kind of step of an assessment. But probably most critically, and this is where some of the administrative burden really comes home to roost, is an employer. So you must give a written notice to each casual employee if you're not going to make an offer, on the basis either that there's reasonable business grounds, or that they haven't worked that kind of regular pattern of work in the past 6 months. And that notice has to both tell them, obviously, that you're not making an offer, but provide details of the reasons for not making that offer. So you need to be really clear with the employee. These are the reasons why we're not making that offer. And again, that has to be given within 21 days after the end of the 12-month period. So it's a reasonably administratively heavy process, and will be particularly administratively heavy for those who engage a significant number of casual employees. Employees, once an offer has been made to an employee, they have to provide a written response within 21 days, identifying whether they accept or decline that offer. If no response is given within that 21 days, they're deemed to have declined the offer, and the casual conversion obligation is parked for a period of time. If they accept the offer, then you're then required to enter into a discussion/consultation process with them about, whether they're full-time, going to go to full-time, part-time, what their hours of work will be, when they're going to start. And you must, within 21 days after their acceptance of the offer, again, give another notice to the employee setting out whether they're full-time or part-time, what their hours of work will be, and the day that it will take effect, which, as you can see from the slide, there must be the first day of the first full pay period after the day the notice is given, unless you reach agreement on a different day. That's not the end of the process. There is an obligation, or sorry, more correctly, a right for a casual employee to request conversion at a later time now, but there's still those same two trigger points. The 12-month service, 6-month regular pattern, and that they must not have refused an offer in the past. They must have not at any time given the employer mustn't have given them notice that they can't make the offer on reasonable business grounds. The employer has not previously refused a request made. The request is not made during the period of 21 days after an employer is required to make an offer. Similar process, must respond within 21 days stating whether it's granted or refused, can only refuse on reasonable business grounds and after consultation has occurred. And that's really important. So there's, again, a discussion period with the employee. So there's a lot of engagement that needs to go on in this casual conversion process. There is Wayne mentioned we'd be talking about the transition period. There's not an expectation that everyone is going to, when this legislation is passed, immediately you need to run a process of dealing with every single casual employee that you employ and determine if they've done the 12 months and what their 6 months has been like. There's actually a 6-month transition period during which you need to complete that kind of assessment and offer and communication process with existing employees. And a further administrative obligation that you'll have, most of you will be, well, I hope most of you are very aware of the obligation to provide a Fair Work information statement to all new employees. There will be an additional statement that needs to be provided to casual employees, and that is, unsurprisingly, the casual employment information statement. So when a new employee starts work, new casual employee starts work with you, you'll need to provide them with both of those statements. There's a level of pressure being put on the government to amend that so that the casual employment information statement is incorporated into the Fair Work information statement, but it seems to me that is in the unlikely mix in terms of things that might change. So that's the conversion process. So we've had the joy of a proper and clear casual definition. We've had the problem of casual conversion, or at least the administrative problem of it. We then have, I think, one of the most important things that's come through this bill, which is the amendments that have been designed to address future and historic underpayment claims. So we know that Skene and Rosado were about people within the black coal mining industry who are earning lots and lots of money for driving machinery, be it trucks or other machinery, were employed as casual, were later deemed to be permanent employees, therefore entitled to NES entitlements like paid sick leave, paid annual leave, redundancy notice in lieu of termination, and were despite being paid a casual loading, were entitled to claim that benefit as well. So those employees both got the casual loading and the NES entitlements to paid leave, etc. This amendment essentially directs a court as to how it is to deal with claims of that nature in the future. And so if an employee if an employee's been employed in a way that's been described as casual employment, they're paid an identifiable amount, which is defined as the loading amount, during a period to compensate them for what's termed the relevant entitlements, which are those NES entitlements that I spoke of, to paid leave and redundancy and notice of termination. That employee was deemed not to be a casual employee. So the employee has gone off to court and it's been determined that they're a permanent employee, and they make a claim to be paid an amount for one or more of those entitlements. So if you look at Skeen, for example, he was claiming predominantly paid annual leave. So he goes off to court and he claims, I'm entitled to 8 weeks of paid annual leave at, $4,000 a week. I'm entitled to be paid $32,000. The court is required under these provisions to reduce any amount payable to that employer, payable by the employer to the employee, by an amount equal to the loading amount, which is the casual loading paid. So if Skeen was paid $40,000 as a casual loading over that period, his claim is reduced to zero. It can't obviously reduce below zero. The employer can't claim back the additional 8,000, but it is reduced to zero. So that's a significant change, and there's 4 or 5 class actions currently in play, predominantly in the resources area, and I've got a couple of clients who have got individual claims against them for permanent employee entitlements where they've been engaged on a casual basis. So really important change, and provides, I think, a lot of comfort. But again, it really is dependent on the way that the employment relationship was set up at the start, because you need the part that's bolded on that slide is identifiable amount, and that will be the most critical element of it. Just because a person's been described as a casual employee is not going to protect the employer in this situation from a claim if they haven't actually identified that there's a casual loading payable. What does it all mean? As I said, it's a bit of a love sandwich. Casual definition, really helpful. I think provides a really high level of certainty that what you label as a casual is a casual. Casual process, a bit of an administrative nightmare. The administrative system, burden can be reduced through systems and processes, so you can kind of automate elements of the process, which is helpful, but there's still that need for some level of human kind of assessment of entitlement and also grounds for refusal. And as I've just said, the double dipping provisions are really significant. As they currently read, they operate prospectively and retrospectively, which means you are protected from historical claims that relate to periods before the legislation commences. And if you've got the identifiable amount in your contract or in the way that you pay, then you can be very confident that you're going to be able to answer any claim. Some kind of tips of things that we think are absolute musts. Getting your contracts right. If you've been through the previous sessions that we've done, we've hopefully giving you enough direction on that. But I think the most critical thing you can have in any contract or casual employment contract is, confirmation that the employee, there's no guarantee of work, that the employee can accept or reject work, and the employer can offer or choose not to offer work. So it's really critical that's in there, because that fits the clear definition. Has to be described as casual, needs to identify that there's a casual loading paid. Another thing that you need to look at is what type of system you can implement to automate as much of the conversion process as possible. Now, this will be determined by the number of casual employees that you employ. If you've got kind of only a small number, 2 or 3, less than 10, the process is actually reasonably straightforward for you. If you start getting into the kind of 20, 30, 40 and above, you really need to have some sort of system that's going to trigger you to identify when you've got to do certain things. Because if you don't do those things within those required timeframes, then you're outside that process. You're technically in breach of the Fair Work Act, and you're subject to kind of challenge from employees about that. Being careful about how you manage conversion offers in the initial period. You've got to be compliant with those timeframes, and you can't just have really flimsy grounds for for deciding not to make offers, or for rejecting requests for those who make subsequent requests. You need to be really, really clear on that. You need to be ensuring that you're not falling foul of those provisions. Employees who want to challenge your conduct or your decisions can raise disputes at the Fair Work Commission in relation to the casual conversion process. That's not it in terms of the changes in the bill. There's a few other reasonably critical things. There's some variations to awards in what are described as distressed industries. So those have been particularly impacted by COVID. But they allow for a level of flexibility for part-time employment, and also extend to an extent some of the JobKeeper flexibility. So some of those rights that you've had if you've been eligible for JobKeeper, to reduce employee hours, direct them to perform other duties, and direct them to work at other locations. So some of those provisions have come in. One of the things that we were going to talk about was the ability to make agreements with your employees that don't pass the Better Off Overall test, but are agreeing to a lower level of conditions in order to deal with the negative impacts of COVID on your business. So if you could, under what was initially proposed, if you could demonstrate that your business was substantially impacted by COVID, that your employees were willing to accept as an alternative to business failure, an enterprise agreement that was lower than the award, then the Commission had the ability to approve that, depending on views of the people, all that sort of stuff. That earlier this week it was announced by the government that they were abandoning that change. There is still a provision in the Fair Work Act that allows a business to have an agreement approved that doesn't pass the Better Off Overall test, and so it's a much more kind of narrow test, and it just talks about it not being contrary to public interest. But most of the things that would have been relevant under the proposed change are still relevant under the substantive Fair Work Act provisions that exist. So if your business is enormously impacted by COVID, and your employees are saying we're prepared to accept an agreement that's less than the award just so we can stay employed, you've got the ability. You still do have that ability, but you must, if you're going to do it, obviously you need your workforce buy-in to it. And you also very significantly need to ensure that you can demonstrate the impacts of COVID on your business and the dire situation your business would be in if you couldn't reach that agreement. Some of the changes that have been retained, there's some changes to agreement making processes designed to speed up approvals and give greater weight to the will of the people. So that they allow for, it just means that the process is not, there are about 6 steps in the process now that if you fail, if you don't comply strictly with the provisions and your agreement fails, they've been kind of rolled up into a single general consideration. So it makes the process a bit easier. There is a provision for the sunsetting of zombie agreements, as they're described. It's a bit of a misnomer, but I'll kind of use the zombie agreements are really strictly the old agreements, old pre kind of Fair Work Act agreements that are still floating around. So agreements that are 13, 14 years old and still in operation, they'll cease operating on in the middle of 2022. So there's still a little bit of time for them, but you need to prepare for that if you've got one of those agreements. And there's a reasonably significant change to the penalties attached with non-compliance and underpayment. So there's now criminal sanctions and just higher penalties for non-compliance, including for corporations. Most critically, in terms of underpayments, there's this concept of value of the benefit. So if you're a business who's underpaid employees by $200,000, whereas previously your fine might have been under $100,000, or your maximum fine might have been under $100,000. There's now an ability for it to be 2 times or 3 times the value of the benefit. So 2 or 3 times the amount that you've underpaid the staff. And don't forget the award. Sorry, I don't know why I've got 2029. I may be projecting forward significantly. Across 2019 and 20, there was a continuation of a review of the modern awards that started, if you can believe it, in 2014. And some of the most recent activities that have occurred, or most significant activities that have occurred, have been what the Commission's called plain language redrafting, which was intended to be making the awards more simple to understand, more simply structured and ordered, but not change the effect of any terms. I think what I would say to all of you is to, if you are operating under the award, just have a look at where your award's gone in the plain language process. One of the most kind of basic things to be mindful of is that you may have structured your contracts around the award. You may have contracts that refer to particular provisions and clause numbers of the award, but those clause numbers have probably changed significantly, and so it might require a going back to your contracts and kind of updating them for that. The other area that got a significant amount of work was the area of overtime for casuals. So the Commission took the view that casuals should be entitled to overtime, and that the disutility associated with working long hours was the same for casuals as it was for non-casuals. And so they've gone through a process that's been a bit of a, included some clear changes to the way casuals obtain an entitlement to overtime, but also some clarification of the interactions between overtime penalties and casual loading. There's essentially a couple of ways that these things can work. There's the compounding way, where the casual loading, the overtime's based on the casually loaded rate. So it might be 1.25 by 1.5 for time and a half overtime, or the casual loading is added to the penalty. So it's if it's a 25% loading and a 50% penalty, rather than those two being multiplied, they're added together to get a 75% amount. I know that probably sounds a little confusing, but it's something to be really mindful of and try to have a look at anything that's changed within the awards that apply to your business. If you're under an enterprise agreement and that enterprise agreement's in operation and it doesn't operate subject to the award or doesn't incorporate the award, then just keep looking at your enterprise agreement, but you will need to be mindful of the award when you go to your next negotiation for your agreement. That ends my presentation.
Thank you, Nick. As usual, doing a great job. We've obviously been doing this a while now and did a lot of work in 2020. Our first one of 2021. So thanks for the presentation. We're going to launch into some questions now, but just before we do, there's a special offer today for everybody. There's a free audit of your business's casual workforce in relation to the content today, conducted by Nick and myself, and we'll step out, that will step out the checks you need to undertake to protect your business. So to make this simple, please write in the chat box the word audit if you want to request a scheduled time, and we can get in contact with you in relation to that. So just type the word audit, and if you want to put an ideal time for you inside the chat box, please do so. And that will come with the recording as well. So let's launch into some questions, Nick. I've got one to sort of get things going, because we've actually got some really good ones, some juicy ones that have come through on the chat box. So well done to everybody, some really good ones in there. First one is, what are you hearing from your clients, Nick, about how they are preparing for the casual conversion process?
Yeah, it's a bit fascinating. So we obviously deal with clients across the broad spectrum. We've got some clients who employ tens of thousands of casuals. They are in the kind of spending hundreds of $1,000s on systems, and that they will need to engage multiple people specifically to deal with this. So in a slightly cynical way, if the changes are about promoting employment, well, they've got an immediate effect, because that business is going to have to hire two additional staff essentially to manage their whole conversion process. Can you imagine if you've got 10,000 casual employees, you're going to be doing hundreds of assessments a week potentially. It's a pretty massive task. At the kind of lower end, people are still looking for systems. So those kind of those systems that will generate an alert as a starting point. So Nick's reached 12 months. There's an alert that goes that says you need to do this, and the system that then can kind of auto-generate some of the communications that need to go out. So we at FCB, for example, we've got an HRIS, so a system that a lot of clients across Australia use to manage their people from commencement to offboarding. And we've had to build a casual conversion process and a whole heap of kind of template documents that can be deployed through the system to meet with that. So there's a lot of work going into systems and identification of who's going to take responsibility for the conversion process. But it's just we don't anticipate, and our clients don't anticipate many people taking up conversion opportunities, and so the amount of work that the business has to do compared to the number of people who are likely to look for conversion is, in my view, kind of completely out of kilter. But that's what businesses are doing. They're just working really hard to get systems in place and people in place to be able to get themselves ready to start the project, because obviously there's also that 6-month kind of transition period where they're going to have to look back at their existing employees and go, okay, I've got to assess where they're at.
Okay. Well, we've got some really juicy questions coming through. So a big thank you to Aaron Fisher, who's put a question which I think is really relevant and was going through my mind as well. If an employee declines the initial offer after 12 months, or if an offer is not made due to reasonable grounds, does the employer need to reassess and make an offer ever, or 12 months after that?
Now, I'm testing my recollection here, Wayne, and I don't want to have to go off and look at the detail of the bill. I think someone who rejects an offer, someone who declines an offer, does not get a second bite at it. The residual right to request, I think, resides with those. So, for example, if someone's been rejected on reasonable business grounds, it would be unreasonable for that to be a kind of an end to the discussion, because if you've said, well, I'm rejecting you because these hours aren't going to be here in 12 months, and in kind of 12 months time those hours are still there, it would be unfair. So my recollection of it is that there's a difference between those who outright reject and those who have had an offer declined to be made.
Okay, all right, that makes sense. I think I know we know the answer to this one, but I'm just going to check. So thanks to David Rundle for the question. What is the process if the 21 days post the 12-month period has expired and the employer identifies a number of employees who meet the conversion criteria? Now, I imagine that still sits with the discretion of the employer.
So you're saying that, is that an employer who's missed the deadline?
An employee, what if the 21 days post the 12-month period is expired and the employer identifies, well, yeah, both, either party.
Yeah, well, I mean, I think if the employer hasn't complied, or hasn't done the assessment and complied with its obligations, it should do so really, really quickly, rather than kind of sit back and let it pass. So if someone's got to the 12 months, you've missed. You haven't got that alert. You haven't got that system. That's a 22nd day, and you go, well, hang on, I've got this person who I should have been through this process with. I think you just need to move really quickly to get into that process.
Okay, that's fair enough. Look, we've probably got two questions, or two of the attendees that have done a very similar question. One of them is Diana Steiner. Thanks, Diana. Good question. Can you please explain the options employers have regarding the sunsetting of zombie agreements? And there was also, on top of that, Nick, was that there was a question in relation to what's the default after the zombie agreements in 2022 finish. Is it a default back to the modern awards?
Yes. So in simple terms, once those agreements sunset, if there's a modern award that exists that applies to those employees, then they'll be covered by that modern award. There's no obligation to go into a new enterprise agreement. You can go back to the modern award. If you obviously we always encourage our clients to do an assessment of what works best for them. If the modern award, if the agreement contains things that really align with the business and allow you to operate more efficiently, and the award's going to change that substantially, then have a think about doing a new enterprise agreement. But bearing in mind, obviously, the new agreement, employees have got to be better off overall, and there'll be that testing process to ensure they are.
Because systematic hours is so central to the demonstration of or key to the conversion and the assessment. Chi Van Douwen has put in a question for us. So thanks, Chi. Does a regular pattern of hours, would this mean that the casual needs to work the same days as well, or only a pattern in hours?
Yeah, it's a great question, and you hate giving the typical lawyer answer, but it does depend. So if for example, if it's a full-time employee, they're doing 38 hours every week, but their day shift. If a full-time employee under the industrial instrument, assume it's an award, if under the award, the hours can move in accordance with rostering provisions, and that employee's been moving their hours in about that way, then that would be regular hours. But if the hours of if the award said full-time employees work 38 hours and they must have a fixed roster, and the roster can only be altered by agreement between the parties, and this employee's been kind of directed by the employer to work, still doing 38 hours, but 1 week they're doing 5 7.6 hour days, the next week they're doing 3 10s and an 8 and that sort of stuff. If it's not aligning with the award, then that's not a regular pattern of hours that they could continue to work. And it's probably more so, as I'd mentioned in the presentation, for part-time employees. There's such a difference between different part-time provisions in awards. Some just have kind of minimum, maximum hours, whereas some have a really fixed kind of requirement of a pattern of hours. And if you've got a part-time employee who you've worked, the hours have changed, or the days change week in, week out, then there's a good chance that doesn't fit within the award provisions, and it raises a ground on which you can refuse to make an offer.
Yeah, that makes sense. Look, I think we've got a very, very good question here, a really good one from Sarge. Yeah, I think it's really a really interesting question. Are employers obliged to offer hours similar to what they did while they were casual? So does it need to be the same offer of hours and consistent with the systematic hours that were demonstrated during the casual period?
Yeah, so it's based on the hours that were worked while the employee was a casual. That you need to engage with the employee and work on the days and the start times and all those sorts of things. But the starting point is the hours that they work during the casual employment form the basis of the hours that they'll work once they've converted.
Okay, interesting. We've got some just a few more questions to go before we call it quits. We've got a couple of questions here. So just a final clarification on the zombie awards in relation to the term sunset. Does this imply their provisions will continue to apply to those who are employed under it before the sunset date, but not to new employees?
No, the agreement will continue to apply to all employees who perform work that's covered by it. So it doesn't mean that from if the legislation passes in April, that employees employed after April don't get to work under that agreement. They still do. It means the agreement as a whole ceases to exist in mid-2022.
Just changing tack slightly with this, what about in relation to the proactive offer of employment, Nick? When should those discussions begin, and what should the nature of them be? You mentioned such an important need to consult, through the process. So, and you said obviously the word or the term proactive offer of employment. When should that begin, and what should the nature of that initial discussion be?
Yeah, I mean, if you're in a situation where you have to make an offer, so you've looked at it, they've worked that regular pattern, there's no business grounds to refuse to make an offer, then you want to be moving really quickly within that 21-day period to engage with the employee. And probably one of the most critical elements of the engagement process, and this is something that a lot of my clients, particularly in your area, Wayne, have seen, is that once they identify for the employee, so employees see that casual conversion, I've got this right to convert to permanent employment, that's going to be awesome. I can't wait to start as a permanent employee. Once you engage with them about what that means, so it means you're going to lose your 25% casual loading. So you're going to be paid a lot less per hour, and you're going to get paid leave entitlements. You're going to have to commit to fixed hours of work. And so that's for us, that's part of the really critical communication process, is making sure that people understand what it is they're getting themselves in for. We know that where casual conversion rights exist, there's only the estimates are somewhere between 3 and 6% of people actually want to convert. So the numbers are really, really low. So, you know, it's really important that you make sure that people aren't going, oh, I can just be made permanent. That's going to be awesome, and I'm going to get the same pay, but I'm going to be a permanent employee. They need to be clear that this is a different type of work. You know, you need to commit to work.
An interesting one. This is in relation to penalties, Nick. So if the stars align and an employer, a casual meets the time frame, the 12 months, and the business grounds are that the employer tries to demonstrate business grounds, but is unable to do so, and the casual employee wants to convert, okay, and that's clear, done in writing, met the 21 days, and ticked all the boxes, but the employer is still in a position where they don't want that casual employee to convert, but they're just unable to demonstrate the reasonable business grounds. What happens? Does it occur that you've either got forced to take the casual employee onto as a permanent employee, or are there fines, or how does it work, Nick?
Yeah, so it's the casual conversion process is going to sit within the NES, and in general terms, breaches of the NES are within the civil remedy provisions of the Fair Work Act, which means that businesses and individuals can be subject to fines, and those fines are in the kind of maximum $60 something thousand area, so they're not insignificant for non-compliance with those provisions. And so an employee who has been unreasonably and unlawfully, so contrary to the provisions of the Act, denied the opportunity to convert, could take action and could have the employer kind of subject to the civil remedy provisions of the Fair Work Act. So it's a pretty significant issue, and I think my view is if someone's the requirement and the entitlement to convert is pretty narrow. Like you do have to be working like a permanent employee, and so there is an argument of why wouldn't you just convert them? If you're worried about while in 12 months' time or in 6 months' time, we might have to make them redundant, and then it's going to cost us money. Well, first of all, they're not going to have the trigger for redundancy, because there's another change to the Act that's really important, is that under the Act currently, or under the interpretations that have been made of the Act currently, if an employee worked as a casual employee for 2 or 3 years, then converted to permanent employment, and 6 months later was made redundant, the entirety of their service would count in terms of calculating redundancy pay. So they'd end up with kind of 8-10 weeks redundancy pay potentially. Yeah.
Look, I think you're right. I mean, I think I'm just mindful of time here. I think the likelihood of turning over is, even from my experience and with the large volume of casuals that we have out working, in getting a casual to go permanent is actually a difficult thing to achieve. Not always not an easy thing. So
it's about conversion with you. So for your people who are working with some of your clients, they're not converting to permanent work with your client. They're still converting.
Yes, correct.
A lot of the time.
With us. Well, look, we're right on 11 o'clock, and we obviously said with the 1 hour. So I think we'll wrap up there. Any questions that don't get addressed to all the attendees, they will get addressed post the webinar with an individual message. Look, I want to put out a big, massive thank you to Nick. Nick, thank you so much, mate. It's been great to have you involved again in another education sharing webinar. It's always a pleasure to have you with us. Thank you to the live audience today. And as a way of saying thank you, you will receive a Symmetry gift pack a gift pack. So to all the audience today, you'll receive a free audit of your casual workforce that will step out the checks you need to undertake moving forward. Of course, some of you, I can see it filtering through already, the requests for a scheduled audit, which we'll obviously get in contact with you about. If you're looking to increase your headcount, Symmetry HR are offering significant recruitment discount vouchers. And of course, we will be sharing the recording of the webinar sent directly to you, to all registrations and attendees to today's webinar. So I just want to say thank you again for everybody and their attendance. Enjoy your Fridays. I hope you got a lot out of today's session. Enjoy your weekend, and thanks again, and we'll see you next time.
Thanks all.